introductions and invite you to speak then. Is that okay?
That's good. Should I mute myself now?
I mean, that's fine. I mean, you can, once the introductions are done, you can start. अच्छा केशव जी start कर दीजिए. Greetings to all those present. My name is Ankit Malhotra, and I am the president and co-founder of the Jindal Society of International Law. Today amongst us we have a titan of the European Union and the laws governing it. But before I introduce our speaker, I would like to introduce the center under which the Jindal Society of International Law is created. The Center for UN Studies aims to develop and create a learning platform on opportunities and limits of the United Nations by enhancing research and building knowledge on how the United Nations systems work, both in terms of institutional development and in terms of promotion and implementation of various multilateral policies. In my discussions with the coordinator of not only the society but also the center, who's also the vice dean of the law school, Professor Dr. Veselin Popowski, he's often reminded me that in 1953, the first UN Secretary General, Trygve Lie, welcomed his successor, Dag Hammarskjöld, by saying the following words, and I quote him, "Welcome, Dag, to the most impossible job on this earth," end quote. The United Nations has often been criticized and turned into a scapegoat when states have failed to live up to its initial expectations. But let us also remind ourselves what Hammarskjöld said famously, and perhaps as a response to this. He said, and I quote him, "The United Nations was not created to take us to heaven, but to save us from hell," end quote. The Center for UN Studies engages in projects studying the history and the traditions, but also takes a transformative approach to research, teaching, and societal engagement, having in mind the latest dynamic, geopolitical, and technological shifts. Jindal Society of International Law, which is created under the aegis of the Center for UN Studies, under the guidance of Professor Dr. Veselin Popowski, in 2020 was inaugurated by Professor of International Law, Professor Jose Enrique Alvarez of New York University, along with the Vice Chancellor, Professor C. Rajkumar, Faculty Coordinator, Professor Dr. Veselin Popowski, and a very dear friend of the Society, Professor Dr. Mohan Kumar. Our fall lecture series of 2021, Exploring the Ecosystem of International Law, builds upon the introduction given to internationalism and international law by the concluded spring lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To assist in this study, the speakers will cover and address their respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and engagement of international law in it, the Society aims to study the fragmentation and fertilization of the various disciplines in this ecosystem. The lowest common denominator in the fall lecture series is to enhance and provide a deeper understanding of international law through international lawyers like the one whom we have today. The Society for its members is a well of knowledge and a quorum of thought-provoking discussion, which will be the resultant of its engagements with the experts who are aimed to explore the ecosystem of international law. Our speaker today will explore the European Union and international law as a head-to-head or a tête-à-tête. This is Professor Nicolas Angelet, who specializes in public international law. His areas of expertise cover all aspects of public international law, including law of treaties, state responsibility, investment law, investor-state dispute settlement, immunities, the law and governance of international organizations, international law against corruption, human rights, including business rights embroiled in those disputes. Dr. Angelet also sits as an arbitrator in ICSID annulment proceedings. He has also been counsel for states and corporations in international investment cases and has represented international organizations, the Belgian government and foreign states for the Americas, Africa, and Europe, as well as corporate clients before domestic courts in Belgium and abroad, PCA, interstate arbitrations, International Court of Justice, European Court of Human Rights. Professor Angelet has done it and seen it all. Professor Angelet is also a member of the bar in Brussels and an associate tenant at Doughty Street Chambers, London. He is also a professor of international law at the University of Brussels. He is a member of the ICSID Panel on conciliators as appointed by Belgium and of the ICSID Panel of arbitrators appointed by Burundi this time. But before I finally hand the floor to him, let me share a few remarks or few readings of mine on the topic which Professor has chosen to speak today. The topic which he will speak about and elaborate upon is like the Russian doll, the matryoshka. These matryoshkas is the rule of recognition of EU laws which excludes, albeit is not identical to the national rule of recognition. This is the recognition of domestic and international laws. It is both external and internal to the national rule of recognition, and this constitutes the essence of legal pluralism. By reference to the notion of interlegality discussions that Professor will highlight, the essence and the motivation remains to capture the legal validity that is granted by legal pluralism in the European Union vis-a-vis international law. With those words, I finally invite our speaker. Professor, the floor is yours.
Thank you very much for inviting me. I'm very grateful to the Society for this invitation. It is seen from Western Europe very impressive how you have managed in only 1 year time, I believe, to become almost world famous and to organize very interesting, stimulating lectures. I've seen at least extracts of the lectures of some of my colleagues and friends, Dan Sarouchi, Laurence Boisson de Chazourne, and I was also impressed to see that both of them mentioned the relationships that they already have with Tyndall Global Law School. So my wish today, before I start my lecture, is that my university could also establish such fruitful relationships in the future. So I'm going to talk, as you have just mentioned, about the relationship between the European Union and international law, how the EU posits itself in international law, and how it is perceived by other actors in the international community. The image of a tête-à-tête that has been chosen by Mr. Malhotra, not by me, is extremely apt, actually. It refers to two individuals looking at each other and communicating with each other. And it reminds me of the saying of a European philosopher, I presume it must have been Jean-Paul Sartre, saying that one only exists through someone else's eyes. Now, a related notion, which also plays a very important role in Western European philosophy, and that has again been mentioned in the short but very accurate introduction, is that of recognition. It is said in philosophy that participating in collective actions, being welcomed by others in those actions, confirms or establishes the very existence of the participant. Now, recognition can take two different forms and pursue two different objectives. A person can seek to be recognized as equal to other members of the group, or to the contrary, it can seek to be recognized as different from the group, as unique. And this is also true of recognition as a legal device. Recognition is an essential function of the law. Each legal order recognizes its own subjects, their equality or inequality. International law recognizes states as its primary subjects and consecrates the principle of sovereign equality between states. But international law also recognizes differences and differential statuses. Minorities and indigenous people aspire to be recognized as different, and the international law on minorities and indigenous people is there to recognize and to organize such differential statuses. To this, I should add one more point on the very nature of recognition. In international law, as students of the law would know, there are two theories of state recognition. According to one theory, recognition is constitutive, meaning that an entity only becomes a state when it is recognized as such by other states. According to another theory, recognition is declaratory, meaning that it describes something, a state that is already in existence. The constitutive approach is performative. It aims at granting, at giving a status and associated rights and obligations, or to the contrary, at withholding that status and its consequences to further a policy objective. The declaratory approach, which one could qualify as descriptive, the declaratory approach, however, does not guarantee uniformity of views among those who are invited to grant or deny recognition. One and the same object may be seen differently from different angles, and as a consequence, also the person or the body seeking recognition may perceive itself differently from others. And that is where the European Union comes into play. My objective today is to analyze the tête-à-tête between European Union and international law from these angles. The central point, I submit, is that the EU perceives itself as different from states, different from international organizations, and indeed as unique, and wants to be recognized as such, but at the same time, it wants to be recognized as a member of the international community, more or less equal, though still different from states. And other international organizations, other states, do not necessarily take the same view on the European Union's alleged or claimed uniqueness, or at times they may turn the EU's claim to an exceptional nature against the EU itself, as we shall see. And so the tête-à-tête is very much about balancing the competing claims, the claim to equality, the claim to difference, and also about harmonizing the different views on what is probably one and the same subject that, however, can be seen differently from different angles. Now, before addressing these issues, I will very briefly describe a number of specific features of the EU, or the European construction, as we call it in French, seen from the European Union itself, and in particular by the European Court of Justice, which plays an important role in the development of EU law, but also in the development of EU narratives regarding its exceptional nature. As you all know, the European Union is composed today of 27 member states, the United Kingdom having left in 2020 after the Brexit referendum. But the EU's inception goes back to the aftermath of World War II, and there are a few important elements that should be mentioned. I will not mention all the treaties, which I would be unable to do for time, but also for complexity. Let me just mention that in 1957, the 6 initial founders of the European Economic Community signed the Treaty of Rome, created the European Economic Community, whose goal was to create a common market and a customs union, and, that is important, to lay the foundations of an ever closer union among the peoples of Europe. And in line with this, in 1964, the Court of Justice of what was then the EEC, now the European Union, in a very famous judgment, Costa versus Inel, which was concerned with electricity issues, not with big, important constitutional issues at first. In that case, the Court of Justice highlighted that, and I quote, by contrast with ordinary international treaties, the EEC treaty has created its own legal system, which became an integral part of the legal systems of the member states and which their courts are bound to apply. Now, as you may note, the formula by contrast with ordinary international treaties in a way already reflects the EU's ambiguous position, because it was at the time at least still conceived as international law. It is international treaties, yet not as ordinary international law. And so we see here already the tension between normality and exceptionalism. Well, there have been many other treaties since then, developing the European integration, which I would say, again briefly, is characterized by 3 distinct elements. First, direct applicability. EU law is directly applicable in national legal orders, meaning that the EU, at least inwards, adopts the monistic approach to the relationship between EU law and the domestic law of the member states. And again, in line with this, the European Court of Justice has highlighted that the EU legal order was, I quote again, a new legal order of international law. A new legal order of international law, which independently of the legislation of member states, I quote, not only imposes obligations on individuals, but is also intended to confer upon them rights which will become part of their legal heritage, unquote. So the court confirmed the independence of the EU legal order, its independence from classic international law, and as you may have noted from the use of the formula legal heritage, this statement of the law by the Court of Justice comes with a distinct community building narrative. A second feature of EU law is supremacy. When EU law enters into conflict with a national norm, the position of the European Union is that the conflict must be resolved through the principle of supremacy of EU law. And here again, in Costa versus Inel, at the end of my lecture, you will think that, and perhaps rightly, I only know one judgment of the ECJ, but perhaps I will know 2. One, again, is Costa versus Inel, where the court said that the law stemming from the treaty, which is an independent source of law, could not, because of its special and original nature, be overridden by domestic legal provisions, without being deprived of its character as European law and without the legal basis of the Union itself being called into question. And later on, the court confirmed that this supremacy applies to the EU treaties, but also to secondary legislation enacted by the European institutions pursuant to the treaties. It is important to note, however, that this principle of absolute supremacy, according to which all EU law prevails over the domestic law of member states, is a European perspective not necessarily shared by all the member states. A more nuanced perspective was adopted by the German Constitutional Court, which considers that it has the power to disapply EU law if EU law violates fundamental rights enshrined in the German Constitution, even though the German Constitutional Court does not exercise that screening insofar as and as long as the guarantee of fundamental rights, the fundamental rights are guaranteed at the European level. And only yesterday, the Polish Constitutional Court judged that some EU laws, specifically clauses, are effectively in conflict with the Polish constitution, which will likely trigger financial sanctions from the EU. And now this, the capacity of the EU to enact financial sanctions to enforce the principle of supremacy, leads us to the third characteristic of the EU legal order, which is core, I believe, to its relationship with international law: autonomy. So the EU legal order has also been qualified by the court as an autonomous legal order. The current president of the court, Koen Leenaerts, a Belgian, explains that the principle of autonomy presents two meanings, as it may be understood negatively and positively. Negatively, the principle of autonomy defines what EU law is not. According to Koen Leenaerts, it is not international law, as stated in Van Gent and Loos. And the author observes that the Court of Justice has continued after Van Gent and Loos its original famous judgments to distance itself from international law, abandoning the expression international law. Now, positively, autonomy provides for the fact that the EU has an autonomous legal order, meaning that it can operate its own self-sufficient set of rules. And that was again stated in Costa versus Pinel, quote, which referred to EU law as something, by contrast with ordinary international treaties, the EEC treaty has created its own legal system. And that legal system is based on the existence of EU institutions, the Council, the Commission, the Parliament, and of course, the Court of Justice. Core to the role of the Court of Justice in upholding the autonomy of EU law is the preliminary ruling mechanism provided in Article 267 of the Treaty on the Functioning of European Union, which is of fundamental importance because, as you will see, it impacts on how the EU behaves in international relations. The preliminary ruling procedure is a procedure by which a national court of a member state may ask a question to the European Court of Justice regarding the interpretation of EU law, which is of relevance for a dispute brought before the domestic court. And the Court of Justice then does not decide the dispute, which is and remains before the domestic courts, but it interprets relevant rules of EU law and renders a judgment on that interpretation, which becomes binding erga omnes, not only for the parties to the domestic dispute, but EU-wide. This mechanism aims at setting up a dialogue between the Court of Justice of the EU and national courts, and it is a very strong mechanism to maintain, to secure the interpretation of EU law, to maintain its consistency and autonomy, because the ultimate interpretation is in the hands of the European Court of Justice. Along the same lines, Article 344 of the Treaty on the Functioning of the European Union provides that member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any method of settlement other than those provided in the treaties. So these are the three main characteristics. And then, in light of this, what is the legal nature of the European Union? Now we are moving towards our target. What is its legal nature from the viewpoint of the EU or from the viewpoint of international law? The European Union is most often described as incomparable because it lays somewhere between international and domestic law. And therefore the question arises, should it be seen as an international organization, as a federal state, a federation of states, or something else? One vision considers that while the EU is not or not yet a federal state, it is no longer an international organization, but rather a legal structure not seen before. And indeed, the European Union is different from classic international organizations, both for political and institutional reasons. From a political viewpoint, the EU stands out because of the level of integration it has reached. It covers an enormous number of legal domains, some even touching on current sovereign functions like the right to issue currency. And further, the EU is also a political corpus with a citizenship and a number of rights and liberties conferred to its citizens. And then further, from an institutional point of view, the EU has an almost federal logic which prevents one to consider it as a regular international organization. So that is I would say, the exceptionalist viewpoint on the nature of the EU. On another view, however, the EU is still situated within international law. EU law may be seen as part of international law simply because, first, it finds its origins in international treaties, and second, international law is flexible and puts no limits to the kind of cooperation that states may undertake through treaties. So there is nothing in international law that is incompatible with the EU as a phenomenon. There is nothing in the EU as a phenomenon that cannot be explained and validated on the basis of international law. And in line with this second view, it is of note that the EU is still composed of sovereign states, recognized as sovereign states by the international community, and which sovereign states are free to leave the Union, as the Brexit evidences. The right to withdraw from the EU is made explicit in Article 50 of the Treaty on European Union as adopted in 2009. So this is the international or internationalist view on the EU, and is probably very much my view, but that is because I'm an international lawyer, not a European lawyer, because I'm looking at the phenomenon from the outside, wearing my international law glasses. But what is sure is that different things, as we mentioned at the outset, or the same objects can be seen very differently when it is looked at from different angles. And that is very much the case of the EU. Now, this moves us further to the heart of the topic. What then is the European Union's relationship to international law? How does it posit itself in the international legal order, and how is it received and perceived by other actors in the international legal order? This starts with a declaration of faith on the part of the EU. Under Article 3.5 of the Treaty on European Union, the EU commits itself, and I quote, to a strict observance and development of international law. And Article 216 of the Treaty on the Functioning of the European Union expressly provides that treaties concluded by the EU are binding on the institutions of the EU and on its member states. So the EU is a civil power governed by the rule of law, both internally and externally. Now look at this more closely. Have three different sets of facts. The first one is the diplomacy of the European Union. How is the EU represented in the international community? In that respect, it is interesting to note that the EU presents itself very much in its external relations as the equivalent of a state. It tends to posit itself so close as possible to the status of a state. First, WTO, that's an easy case. The EU has been a member of the World Trade Organization since 1995, but that is made possible by the WTO itself because membership in the WTO is not limited to sovereign states. Any state or customs territory having full autonomy in the conduct of its trade policies may become a member of the World Trade Organization. So EU membership is unsurprising because it is a customs union, but still the EU member states are equally members of the WTO, and each member state is represented independently and in its own rights in parallel with the EU, which is evidence for the fact that the EU is still not treated as any other state or any other member within the context of that organization. More relevant, perhaps, the United Nations. At the United Nations, membership is reserved to sovereign states, and it is therefore reserved to the member states of the European Union, as opposed to the EU itself. Still, the EU has had a permanent observer status since 1974, and it has enjoyed enhanced participation rights since 2011. In May 2011, the United Nations General Assembly adopted a resolution granting the EU the ability to speak early among the major groups when speaking on behalf of the EU member states. And the General Assembly further invited the EU to intervene in the general debate at the Assembly at the opening of the session. And the EU representatives can therefore present their positions of the EU and of the member states at the UN. So this is an enhanced status indeed. And in addition thereto, the EU also has the right to orally present proposals and amendments, and a possibility that no other observer has to reply once to a speech regarding EU positions. So the EU has a very exceptional status at the General Assembly. What it does not have is voting rights. But the most striking aspect of EU diplomacy and EU representation arguably appears in bilateral relations, where EU delegations have long been granted diplomatic status, which is usually reserved to state representatives. Now, this is the case in more than 130 third countries and international organizations. The EU heads of delegation are accredited to third states at the level of heads of state or government, as state representatives are. And since 1983, this is more telling, the rank of ambassador and the use of the associated courtesy title have been explicitly stated in EU letters of credence. So the EU has an ambassador in third countries as if it were a third state. And more about protocol, the head of delegation, from a protocol perspective, the head of delegation of the EU is classified as the lowest of the state heads of mission, holding rank of ambassador, sorry, this is a bit complex, coming before heads of mission of lower rank. In other words, if, for example, the corps diplomatique attends the funeral of a former head of state, first come the ambassadors of third states, according to seniority, then comes the ambassador of the European Union, and then come heads of mission, chargés d'affaires of other states and other international organizations. Importantly, or perhaps amusingly, following Brexit, which took effect in January 2021, the UK Foreign Office very shortly refused to grant that same diplomatic status and privileges to the EU ambassador, as it had done before, and as the EU ambassador enjoys in all other third states of the world. And the UK argued that that was because the EU was not a nation state and should then therefore rank with international organizations. However, ultimately, the Prime Minister of the United Kingdom went back to previous practices and granted diplomatic status to the EU representative. Now, in conclusion on this point, what we see first is that the EU seeks to be treated as much as possible as a state, and it is treated very much in that way, but of course it does not seek to be recognized as a state formally, and it would certainly not be recognized as a state currently. Along the same lines, the international community recognizes the specificity of the EU, but still it recognizes it as a specific phenomenon under international law. This is because as long as the EU member states are recognized as sovereign states, which they are members of the United Nations, As long as the EU member states are recognized as sovereign, the EU is, from the perspective of international law, bound to be a construct of international law. It is a construct made by the primary subjects of international law, states. You will also have noted that the recognition granted by the international community has a distinct sense of constitutive recognition. There is no pre-existing legal basis for the granting of diplomatic status to a non-state. There is nothing in the UN Charter, nor elsewhere in UN law, that provides for a status of enhanced observer when predetermined conditions are met. The EU was offered that status. So the EU is given a lot by the international community. It is given a lot of recognition, and certainly it gives a lot in return. For example, the EU is the single largest provider of development aid on the planet, but the EU is not always as generous. In particular, that will be my next point, it is a rather cool lover of some international institutions, notably when their action may imperil the EU's autonomy. And that is why I talked about autonomy in the first place. The EU, as I said, is a cool lover of international institutions. And that is because it jealously guards its autonomy from two different perspectives. First, it protects its institutional setting, which is the backbone of its autonomy, notably the functioning of the EU judicial system. Second, it protects fundamental principles and values. The first aspects can be illustrated by opinion 2/13 of the Court of Justice, which is an opinion of 2014, which was concerned with the accession of the European Union to the European Convention on Human Rights. Now, we enter the drama of European terminology. The European Convention on Human Rights is not an EU instrument. It is an international convention to which 47 countries are parties, which is concluded under the aegis of a traditional regional organization, the Council of Europe, not the same as the European Union. And the ECHR, European Convention on Human Rights, has established a regional human rights court, the European Court of Human Rights, which is directly accessible to individuals who consider that their rights or freedoms have been violated by a state party to the convention. Now, all the members of the EU are parties to the European Convention on Human Rights, but the EU itself is not, and it has contemplated to become a member. And when that was contemplated, at some point in time, the European Commission asked the court, the European Court of Justice, for an opinion on whether the contemplated modes of accession of the EU were compatible with EU law. So in a way, the Commission asked permission to the Court of Justice for the EU to become a member of, to become a party to that other instrument, the European Court of the European Convention on Human Rights with the European Court of Human Rights. Now, in substance, the Court of Justice said no. It said no because there was an analogous corpus of international human rights norms in EU law, which should be protected. It said no because the mechanism of the European Convention on Human Rights might be incompatible with the mutual trust that exists and that must exist by law between EU member states. And it said no because the mechanism was incompatible with the preliminary ruling procedure under Article 267 of the Treaty on the Functioning of the European Union. Briefly, the second problem about mutual trust is the following. Under the European Convention on Human Rights, a state may be obliged to determine whether a third state complies with basic human rights standards. For example, a party to the ECHR, which is requested to extradite an individual to a third state, must determine whether the fundamental freedoms of that person will be safeguarded in the state requesting extradition. Still, under EU law, that is not permitted as between EU member states because of the principle of mutual trust, which prescribes that member state A, Belgium, must presume that member state B, the Netherlands, will comply with EU law, including the fundamental rights consecrated by EU law. So there is a form of solidarity between EU member states, which prevents the application of ECHR jurisprudence. In the same manner, the ECHR system provides that states may ask the European Court of Human Rights to give advisory opinions on questions of principle regarding the interpretation of the European Convention on Human Rights. Still, the court says, in an EU context, these questions must be asked to the Court of Justice on the basis of the preliminary ruling procedure. So what we see, I know this is technical, but what we see is that the need for the EU to preserve its autonomy appeared to be an obstacle to an otherwise normal form of international cooperation. All the member states of the EU accept the system of the European Court of Human Rights. The EU considered that its fundamental principles governing its functioning stood in the way of that mechanism of otherwise totally normal, acceptable, and indeed valuable means of international cooperation. A second example, the famous CADI 1 and 2 judgments. So the second aspect of EU autonomy and the ensuing cool relationship with other international institutions focuses on substantive principles of the law. And it is illustrated by the judgments of the Court of Justice in the so-called CADI cases, where the court denied effect to Security Council targeted sanctions because they violated the fundamental rights of the targeted individuals. So this is concerned with sanctions against the financing of terrorism. After 9/11, the United Nations Security Council adopted binding decisions under Chapter 7 of the Charter for the purpose of maintaining and restoring international peace and security, ordering the freezing of assets of people associated with Osama bin Laden and the Taliban. These were binding United Nations decisions. The EU then adopted regulations in order to give effect to these decisions. And then Sweden, an EU member state, gave effect, applied these regulations, and froze Mr. Kadi's assets, Mr. Kadi being a Swedish national. Now, the freezing took place in accordance with United Nations decisions without any court hearing. And Mr. Kadi challenged the legality of the freezing measures before the Court of Justice arguing that he had no right to an effective remedy, no access to justice, and that his property rights had been violated in violation of fundamental principles of human rights as guaranteed by the EU. Now, importantly, when the issue of the relationship between the United Nations Charter, basically, and the EU treaties was raised before the European Court of Justice, at first there was a way out, namely Article 351 of the Treaty on the Functioning of the European Union, which recognizes an exception to the supremacy of EU law to the extent that it states that the rights and obligations arising for member states from agreements concluded before the EU treaties or before the accession of the member state to the Euro treaties, and which have been entered into by a member state with a third country, shall not be affected by the provisions of the treaties. In other words, when Belgium, as a member state of the EU, entered the European Economic Community in 1957, it remained entitled to satisfy its obligations under treaties with the United States, with China, with India, the EU law notwithstanding. And one might have thought that this was the way out to make it possible for, or to govern the relationship between the UN Charter and EU law, because the UN Charter obviously is a treaty entered into with third parties, which is anterior to the founding treaties of the EU. Still, the EU in CADI, the Court of Justice, ruled that Article 351 cannot be understood to authorize any derogation from the principles of liberty, democracy, and respect for human rights and fundamental freedoms enshrined in Article 2 of the Treaty on European Union as a foundation of the Union. And this Court of Justice then held that the implementing regulation was invalid in EU law because it violated the right of defense and, more specifically, the right to an effective remedy and the right to property of Mr. Kadi. The court considered that no international norm, even a United Nations Security Council decision, could be implemented into EU law if compliance with the international norm would entail the violation of EU fundamental rights. Now, the court insisted that this did not amount to a review of the lawfulness of the Security Council measures. The review of lawfulness only applied to the EU Act giving effect to the EU Security Council decision, not to the Security Council decision as such. And the court further considered, importantly, that the EU must respect the undertakings given in the context of the United Nations and take due account of the resolution, and that it was for EU member states to act within the United Nations to solve the problem arising from that conflict. But all these nuances notwithstanding, the result was one of non-compliance with binding UN Security Council resolutions that were deemed incompatible with the fundamental principles of the EU legal order. So what we see is that the EU legal system is monistic at the inside. As I mentioned, it's one of the three pillars of EU legal system. It is monistic at the inside when it comes to regulate the relationship between EU law and domestic law of EU member states, but it is markedly dualistic at the outside when it comes to regulate the relationship between EU law and international law outside the EU. What we also see is that the court's finding in Cadi is difficult to reconcile with the qualification of EU law as international law. If EU law were qualified as international law, Article 351 of the TFEU would apply unreservedly. If EU law were qualified as international law, the relationship with the United Nations Security Council resolutions would be governed by Article 103 of the United Nations Charter, which consecrates the supremacy of obligations under the Charter over any other international agreement. Still, I say difficult to reconcile with the qualification of EU law as international law, rather than incompatible, because from an international law perspective, the Court of Justice's approach can still be explained on the basis of its institutional role as the guardian of the EU treaties. Further, very importantly, what must also be emphasized is that the EU's protecting its autonomy goes combined with a constructive engagement with the international community, with the other international organizations to overcome the disagreements. The EU stands by its autonomy, but it does not, as one says on social media, ghost its contacts. It maintains communication and seeks to cooperate in order to overcome the issues raised. And this is core to the balancing act between the EU's quest for recognition as a peer member of the international community, on the one hand, and its quest for specificity on the other hand. The EU is a norm exporter, which seeks to set the highest standards in many fields, human rights, as in Cadi, but also in environmental matters, regarding data protection. And in a globalized world, it is a challenge indeed to uphold these high standards, even internally, while remaining engaged in international cooperation. And the EU does steadily take up that challenge. A last point, if, Mr. President, you would allow me 5 or 10 more minutes at most, is that okay? 5 minutes, thank you. Now I move to international law in the relationships between EU member states. This is the famous Achmea and Comstroy jurisprudence of the European Court of Justice, which is concerned with international investment treaties and their intra-EU application. In two important judgments, the Achmea judgment of 2018 and the Comstroy judgment, which was rendered only on 2 September of this year, the European Court of Justice has been brought to decide whether investor-state arbitration, provided for in a bilateral or multilateral investment treaty between EU member states, is compatible with EU law. Now, the facts of Achmea are the following. Achmea is an insurance company from the Netherlands, EU member state, that made an investment in Slovakia, another member state. And at some point, Achmea brought an investment treaty claim against Slovakia under the Netherlands-Slovakia bilateral investment treaty. And this led to an arbitral award granting Achmea damages in the amount of 22 million euros. Slovakia then sought annulment of the award before the German courts, and this court, the German Federal Court, to request a preliminary ruling from the Court of Justice concerning the compatibility of the arbitration provision in the BIT with EU law. And the court noted that the law applicable by the tribunal, by the Investment Arbitration Tribunal, included EU law. And in that light, the German court asked the Court of Justice to determine whether the BIT, the arbitration provision, violated, again, Article 344, preliminary ruling procedure, or Article 267 of the Treaty on the Functioning of the European Union. And the court, rather unsurprisingly, in the light of Opinion 213, found that an arbitration provision of that nature was contrary to the autonomy of the EU legal order, violated Article 344 and 267 of the TFUE. And the court further held that the clause violated the principle of mutual trust between member states, again, in that providing for investor-state arbitration amounted to manifesting distrust towards the rule of law in the other member state party to the investment treaty, something that may not be done between member states of the European Union, because we are one and the same family, and we must trust each other. That is the constitutional message. And a similar judgment was delivered more recently in Kamstroy. Now, this might be entirely unsurprising, unproblematic, insofar as the relations between two EU member states are concerned. At first, there is no extraneous actor involved who might dispute how the European Court of Justice subordinates, as it does, an international treaty to EU law on the basis of what the Court of Justice itself qualifies as EU constitutional principles. However, there is an external actor involved, which is a tribunal set up under the bilateral investment treaty. And these arbitrators look at the phenomenon and at the case law of the Court of Justice from an outside view, from the viewpoint of international law, one would expect. And remarkably, 50 or more arbitral tribunals have until now taken a different view from the Court of Justice and have upheld their jurisdiction under intra-EU investment treaties. Remarkably also, this case law partly evolves around the qualification of EU law as international or, to the contrary, as domestic law. In one instance, ASPNB Banca versus Latvia, the arbitral tribunal considered that since the EU treaties have, and I quote, binding effect anchoring in the domestic legal system, Article 27 of the Vienna Convention on the Law of Treaties applies, meaning that a state may not rely on its domestic law as a justification for its failure to perform its obligations under a treaty. And as an author comments, it is therefore stated that from a public international law perspective, one states the relevant principles expressed in Achmea and Kamstroy are a manifestation of EU constitutional law, and therefore they qualify as internal law, with the consequence that pursuant to the law of treaties, it is not authorized to rely on EU law qua domestic law to violate, to justify non-compliance with an international treaty. So, and here one sees that the ECJ's approach that consists in highlighting EU law as constitutional law rather than international law is in a way turned against it. And in my view, that is incorrect. Perhaps EU law is constitutional law from an EU perspective, but from a public international law perspective, it is bound to be international law. That is because the EU legal order is based on treaties and because the EU simply is not a state. For the international legal order to recognize the EU legal order as domestic law, it should recognize the EU as a sovereign state, which it does not. So the international legal order cannot conceive of EU law as domestic law, as long as it recognizes the member states as sovereign states. And neither, importantly, neither is an analogous application of Article 27 of the Vienna Convention on the Law of Treaties warranted. Because what Article 27 states is that a state, the Netherlands, no Slovakia, may not oppose its constitution to another state, the Netherlands, so as to undo its undertakings under international law with that other state, the Netherlands. Because the Netherlands is entitled to say, wait a minute, Slovakia, that is your constitution, not mine. I am not a party to your constitution. I am a party to the treaty. So that would be relevant in the relations between an EU member and a third state, which is not a party to the EU constitutional system. But it is not relevant to the relationship between two EU member states who have the EU constitutional system in common. So the reliance on Article 27 of the Vienna Convention is misguided. And so now is, I think, the core of the issue of how one perceives the EU and the international law or EU law. One may ask, does then my position, does it not amount to unfairly allowing the EU to have its cake and eat it? Don't we allow the EU to, or does not the EU seek to take the advantages of the qualification as constitutional law in CADI, where it says no treaties apply where our fundamental principles are at stake, and then in other instances to be granted the advantages of international law. So first of all, I would say the EU does not quite have its cake and eat it. It does protect its autonomy, but also constructively engages with the international community to overcome divergent positions. Second, perhaps it is rather the investment tribunals who want to have their cake and eat it, who are cherry-picking. If investment tribunals wish to confront the EU with its own constitutional approach, they have to go all the way. That is, they must also adopt the consequences that the Constitutional Court, the ECJ, attaches to its finding of unconstitutionality. But in truth, again, investment tribunals should not adopt the constitutional approach. They are bound to do that. They are bound to consider the issue from the angle of international law, whatever the EU may say. Investment tribunals must approach the issue, must approach the EU as a phenomenon under international law, because they are hearing a case based on an international treaty entered into by two or more EU member states as sovereign states. And they are therefore bound to take the view that as long as the EU is composed of sovereign states, which is at the basis of the very existence of the arbitral tribunal, there would be no investment tribunal without sovereign states. As long as that is the case, international law is bound to qualify EU law as international, not as domestic law. So to conclude, the Court of Justice terminology, I would suggest, must be taken for what it is. It is obviously a matter of norms and a matter of judge-made law, but it is also a matter of narratives. It is a matter of language, terminology, used not only to formulate norms, but also to contribute to union building, not to say nation building, to shape the EU identity, to shape the EU integration, which is a process supported by a narrative. And this narrative and how the EU conceives of itself is one thing, but it cannot cause other actors to disqualify the EU and EU law as specific phenomena of international law. EU law is arguably more than ordinary international law, which explains the qualification as supranational, but it is not less, and it is most certainly not domestic law within the meaning of international law. Thank you so much for your kind attention. And if there are any questions, I will do the utmost to answer them, knowing that, again, I am not an expert in EU law, just an international lawyer looking at the phenomenon from the outside. Thank you.
Well, Professor, what I can say is there was a riveting and a tour de force of not only international law but European law. I have a couple of remarks, but I'd request our audience members to share their thoughts, comments, questions, whatever they wish to in the chat box, and we'll take them up later. First of all, on a literary front, not on the law front, Professor mentioned you can have your cake and eat it. This was, in the modern English language, first used by Jonathan Swift in 1738 in a farce of the polite conversation in the character of Lady Answerall. The name Answerall perhaps answers the question as well. And the phrase was, this is something I find rather interesting when I'm studying law and international law in different languages, is that it was used in the reverse order. And I just thought I should share that small anecdote on this, and the account I shall be more than happy to share. The other aspect which I would like to share is that I've opened the curtains behind me. I am not in the usual space I am, but I am in a space which allows me this creative freedom of expression. The expression I wish to convey as a remark to Professor and his address, that opens the windows of thought and perception and understanding due to his address, so I'm thankful to him. This place, the chateau, is a colonial vestige, and as I was sharing with Professor before we started, another colonial vestige is the European Union, and I remark specifically in the context of the involvement of Sir Winston Churchill, who I happen to have studied quite a lot and have written about as well in the context of the European Convention on Human Rights and the European Charter of Human Rights. I, in fact, Professor, received word from his great-grandson, Randolph Churchill, who was congratulating me on a presentation I made on Churchill's interventions in the European Convention on Human Rights. But more specifically with respect to the address, my initial thoughts got some sort of confirmation and validation with what you spoke in terms of the fragmentation and plurality which comes with respect to international law and how the European Union operates in this specific ecosystem. It's with fragmentation, how at least I would understand is that conveys ideas as a sort of a whole, but this whole can be broken down into fragments and then later placed on together as well, which sort of becomes this collective part. Plurality, on the other hand, is this relationship between the legal orders and the multiplicity of norms and the discussions, which then sort of deviates towards monism and dualism, which is perhaps another discussion entirely. The hierarchy which gets placed, especially in the European context as well, vis-a-vis domestic systems, and Professor highlights this in the case of Poland as well, which will now face sanctions. So there are these examples, and these examples are increasing in number, unfortunately, for the European Union. I would like Professor to ponder more thoughts upon this as well, and especially the Eastern European countries, which seek to be members of the Union for benefits which I should not share but are known to all. But there also remains this 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 attitude which is adamant to stick to their values, and for good measure. You're not really, you do give up some sort of autonomy when you sign up to a treaty, but you don't give up it entirely, which becomes problematic in the context of human rights, which is sacrosanct to the state and how it understands it. The other point which I would like to share, and I go back to Churchill over here, who propounded the idea of a United States of Europe, similar to his experiences in the America. Uh, the project was envisaged in that sense that it became, and this is what Professor highlights in his talk as well, as a sort of a project for political aspirations, but then it devolves itself into economic and financial measures as well, and we all know how that has panned out. I request Professor to share his thoughts on that as well, on the accelerated growth of this European imagination, and whether are there limits to it or not, or whether there should be limits to it or not. And this is perhaps in the context of how Brussels and Berlin work, and who is the de jure and de facto leader, and his opinion on that. And whether can states envision a United States, whether European nations can envision a United States of Europe, or is it just one of those ideas which will die with time and with thought, and also with lack of recollection? And can we in Asia imagine something like this, given how complex we as a society are, and one cannot really even pinpoint what Asia is per se? So I request Professor to share his thoughts on those rather large comments which I have.
Thank you. I would say, in the light of the few elements that I have mentioned before, that the United States of Europe, again, is very much a narrative, right? It is a very well chosen formula by a great speaker. It probably has no predefined contents. It did have a very clear content when the formula was used by Winston Churchill, because at the time, almost the only comparison was that of sovereign states. So the United States of Europe would amount to the states of Europe relinquishing sovereignty. But that is what they have done in the meantime. They have not relinquished all their sovereignty, but they have transferred sovereign rights to the EU, albeit with the reservation that they can take them back anytime, with some difficulties. And so I think very much the United States of Europe are very much a matter of gradation rather than a black and white phenomenon. And in many areas, they have been realized. Obviously, they have not been realized, for example, in the sense that the EU is not a military power, but that, according to the wishes of some statesmen in Europe, might still perhaps be something to come. And if it does not come, it is not an obstacle to EU integration as it presently functions as a civil power.
That's interesting, because I can then juxtapose this idea of the European version to the African version as well. And this is an idea which was very dear to Gaddafi, who propounded a United States of Africa. So perhaps the idea of union, especially after wars, is quite important, and states do it. But I do study this in the context of pandemics as well, in the sense that pandemics and the line which perhaps ran with the world after the Second World was, never again should we have a world war. The same runs in the context of pandemics as well. Never again should we have a pandemic of this gravity as well. In that sense, bilateralism and multilateralism become key, multi perhaps more so. So how can the European Union perhaps lead by example without becoming a new colonial perspective, or a new colonial object? Because the third world is very quick to jump to that conclusion, might I add, unfortunately.
That's an excellent question indeed. And I have no ready-made answer to your question. I think perhaps the most subtle way for the EU to lead by example is when it acts as a norm exporter, not because it seeks to impose its norms to the outside world, but just because it practices high norms in the internal sphere, and other actors in the international community are induced to align with these norms for the purpose of maintaining harmonious relationships. I would say, well, but it is always a delicate issue. For example, if we revert to the case of Cardi, it is clear, I believe, that while at first, as an international lawyer, I was very shocked at the judgment of the Court of Justice, denying effect to Security Council resolutions for the maintenance of international peace and security. But it must also be said that thereupon, the EU's constructive engagement has led to a significant improvement of the United Nations sanctions system. So this is very much a positive story, which I don't think is not colonial or arrogant. It has led to an improvement of the system. Likewise, probably in matters of in environmental matters, I believe it is very much the same. High EU standards are becoming attractive to the outside world, albeit because third parties have to comply with high EU environmental standards to sell their products on the EU market. But again, it is a permanent effort. And regarding data protection, we in Europe have been horrified by all that is referred to as GDPR, the General Regulation on Data Protection, which has an enormous and probably positive impact on the protection of privacy, therefore of individual rights, but also has caused problems for international organizations. There have been problems raised by the fact that the United Nations peacekeeping missions in particular, if I'm not mistaken, had problems organizing their functioning because GDPR requirement, data protection requirements on the part of the EU were de facto creating obstacles to the appropriate running of these missions. So it is an issue of permanent constructive engagement by the EU and by its counterparts.
Okay, I've got two questions. Well, one is mine. There is another one which is addressed to me personally. The one which is in the chat box sent directly to me is, would it be right to ask about privacy, data privacy, which Apple and other softwares, social media is affecting how we as humans live and survive. Recently, there was a ban imposed by the European Union and fines on these social media platforms under the GDPR. And if you could share your thoughts on those and how essentially there's this is perhaps again another tête-à-tête between these organizations and these multinational corporations.
Yes, well, perhaps I think I have said what I can say on that topic before the question was asked, and quite unfortunately, it's extremely technical, and I am not in a position to further comment on that issue, unfortunately.
The other question, which really I've studied in presentation for my work on the European Convention on Human Rights and Britain specifically, given Brexit, but also generally the legacy which they have, is that the effect of the European Court of Human Rights as a normative creature and also creator is very powerful. It has led to some landmark legislations like the Modern Slavery Act and same-sex marriages, of course, in Ireland. So can you perhaps share your perspective of a larger role that the European Convention has played as an enabling agent for countries specifically, given its jurisprudence and its expansion?
Again, that's a new tête-à-tête, right? This is going to be a long silence, I'm afraid. There is so much to say.
Well, perhaps you can reflect on the Eastern European region and that Baltic region belt, because that really seems like a contour of of area which is really not aligned with the predominant European perspective, which would be shared amongst the tripartite of Italy, Germany, and France. So how it reflects in the Eastern European region and their jurisprudence. You've already reflected Poland as an example, as an outlier. So you can build on that, including Hungary and others who are such.
Yes, indeed. Probably the tensions that we have stem from the fact that in the same way as the European Union has gradually expanded and then has come with what we refer to as the acquis communautaire, in the sense that when new member states enter the Union, referring to the EU, they have to accept EU law as it stands at that moment. But of course, those who have been members from the start have been able to build it, to shape it, and also to get accustomed to it over a long period of time. And so inevitably, the acceptance of the acquis communautaire, the true acceptance of it, it's easy to sign, but then for truly accepting and incorporating it, that it can create tensions which it did not necessarily create for the original member states. And the same is true of the European Convention on Human Rights, which was expanded to former Eastern European countries after the demise of the Soviet Union. And there again, there is an issue of having to accept a very well-developed, slowly developed jurisprudence that for us Belgians, which are really the core, the original founders, has come gradually and slowly. and which comes much less gradually and from abroad for the new member states. So I think these are growing pains, basically, and we must try and handle them as growing pains, and again, remain constructively engaged in overcoming them. That's what I can say. Beyond that, obviously, what one also has is that the European Convention on Human Rights does not have the same practical impact in the same concrete areas for each member state. At some point in time, for a state like Belgium, the impact of the European Court of Human Rights had, in a way, I would say, become minimal. It was really on detailed issues, whereas for other states, it is very much concerned with severe and sometimes massive violations of human rights because their social and economic condition is different. And then again, there is a total different experience of the same treaty and the same jurisprudence because it impacts differently depending on the concrete situation of the state.
Well, thank you, sir. That was a thought-provoking answer, and so was the discussion. I don't see any further questions, and I'd request and give you the floor back for final words and comments, and then we can close this session.
Thank you so much. I have no closing remarks to make except to thank you again for your kind invitation. It was a real pleasure to be in India with you today. And as I said, I hope that we will manage to have contacts in return and to welcome you in Brussels, either in person or virtually in conferences organized here in the European Union. Thank you so much again.
Thank you so much, sir. I reciprocate the invitation to you, to our university, not only to the university, but to this beautiful chateau that I habitate in for at least a week. It was riveting hearing from you, and a powerful course and a direction which you have steered this discussion in. You've given us a lot of food for thought, and we're so grateful to you for sparing time, accepting our invitation. We shall of course be in touch through mail. Thank you so much, sir. It was excellent, and we've enjoyed the discussion thoroughly. Thank you so much. Thank you, and good evening.
Goodbye. Goodbye to all.
Thank you.